think they're ready to surrender.
आईएनए की बागी फौजियों पर अंग्रेज देशद्रोह का मुकदमा चलाएंगे।
उन तीनों के बचने के चांसेस कम हैं।
ये कोई आम केस नहीं, कोर्ट मार्शल है। बोला भाई, ये केस आप कांग्रेस के लिए नहीं, सुभाष बोस के लिए लड़ी।
Lieutenant Gobak Singh Dillon, Captain Shah Nawaz Khan, Captain P.K. Sehgal. Section 41, waging war against the king. You are charged with murder. Do you plead guilty to the charges read out?
ईमानदारी से आजादी के लिए लड़ने वाली अगर कोई फौज है तो उसका नाम है आजाद हिंद फौज।
Safety, honor and welfare of your country comes first, always.
British Indian Army hand you over to the Japanese Imperial Army.
हिंदुस्तान और अंग्रेजों के बीच एक धागा था, वो टूट गया।
इस बार कुछ ऊपर नीचे हुआ तो देश में बवाल मच जाए। अब जनता किसी अंग्रेज को नहीं छोड़ेगी।
रात दिन अपने सीने विच वजदी आजादी दे राग नू बंद कर ला।
अंग्रेजी अफसरों ने साडी हिफाजत नहीं की, तो वो हमारी वफादारी के हकदार किस तरह हो सकते हैं?
आज हिंदुस्तानी फौज के पास अपना असली मकसद है, हिंदुस्तान की आजादी।
तुम मुझे खून दो, मैं तुम्हें आजादी दूंगा।
ये मुकदमा पूरी इंडियन नेशनल आर्मी का है।
क्योंकि हमने वो दिन देखा है जब हमें ऐसा लगा था कि हमने हिंदुस्तान को वाकई आजाद कर दिया।
देश की आजादी की लड़ाई कोर्ट में लड़ी जा रही है और इस वक्त पूरा देश एक साथ तैनात है।
This trial and its judgment shall be remembered throughout history.
Hello and welcome. I'm Amritanshu Rai and you're watching Constitutionally Yours from Gauhati High Court, Old Building. This is a beautiful campus. In this program, the Constitutionally Yours, we attempt to demystify provisions of the Constitution, and today we will be dealing with issues relating to Assam. Joining me in this endeavor are a distinguished panel of guests. I have with me Justice B.K. Sharma, retired judge of the Gauhati High Court, nominated by the Chief Justice of the Gauhati High Court. I also have with me Mr. Siddhartha Bhattacharya. He is member of Legislative Assembly, Gauhati, nominated by the Speaker of the Legislative Assembly, Gauhati. And Mr. Sherman, who is member of Legislative Assembly, Gauhati, nominated by the Leader of Opposition, Gauhati Legislative Assembly. Joining us in this audience are a group of young students from National Law University and Judicial Academy. Straight away to the topic at hand, which is as the sixth schedule, which is for the tribal areas. Now, this is a specific provision and applies to the state of Assam and has been under implementation for a long time. As it appears in the Constitution, Article 338A, there shall be a commission for the scheduled tribes to be known as the National Commission for the Scheduled Tribes, and it prescribes how the powers of the commission and how it has to benefit, deliver more and more to the tribal regions. The idea is, has the commission been able to deliver, or is it, sir, my question to you is it a merely recommendatory body and is not effective enough?
Article 338, Article 338A is a new insertion. The Constitution was amended in 2004. Earlier, under Article 338, it was a composite commission, National Commission for Scheduled Caste and Scheduled Tribe. Then National Commission for Scheduled Tribe was bifurcated in 2004 by bringing an amendment, and Article 338A was inserted. Now, National Commission for Scheduled Tribe is constituted. It is headed by the chairperson, vice chairperson, 3 other members, all to be nominated by the President of India. Now, this commission has been constituted to look into the grievances of the scheduled tribes. What are their grievances? What are the requirements for their upliftment, their developments? if any complaint is received that these particular tribal communities have been tortured or some injustice has been done, those complaints are to be looked into. And this commission is required to submit annual report to the president, and it is the report is also placed before the parliament.
True.
Likewise, if any recommendation is made or any report is furnished in respect of a state, then it is required to be placed before the governor and also before the assembly. Now, provisions have been made. The commission is to monitor the functioning of the scheduled tribe areas, scheduled tribes, whether their developmental activities have gone or any upliftment is required, whether any addition is required, further developmental activities are required or not. And as I have said, if any complaint is received, that complaint is to be inquired into. All these things are there. Now, as regards the power, it has been given the power, as per the provisions of the Civil Procedure Code, it can summon a witness, it can examine the documents, but the Supreme Court, in fact, in a particular bank case, an injunction order was granted. Then the question arose before the Supreme Court in 1996. If I may give you the citation, it may help you. 1996, 6 SCC 606, page number is 606, 1996, volume 6, SCC 606. In that particular case, what happened, the National Commission for Scheduled Tribe, it granted injunction order. So the Supreme Court said that no, you cannot grant the order, you do not have the power to grant injunction. It is absolutely with the civil court. So that has been held, but nonetheless, it has got power under the CPC to summon witnesses, to examine documents, to arrive at a particular finding. Thus, these powers are given. It is a recommendatory body, and the upliftment implementation part is with the central government. That is there.
So, paper tiger?
I don't think so. I don't think so, because since independence, if you look into the constitutional debates, you were referring to the 6th schedule that pertains to Assam. In the constitutional debates, you will see that has been debated very elaborately why certain section of citizens need some special care, and because of that, when India was it became an independent state, and when we constituted our constitution, we had incorporated this particular provision there. I think over the years, the commission in its earlier form as National Scheduled Caste and Scheduled Tribe Commission has performed and has been able to make much progress, but subsequently it was also felt that tribes, particularly the scheduled tribes, they have somehow or other lack in development as considered to others. So it was felt that there should be a separation of the Scheduled Tribe Commission, and that's exactly why this provision was made and a bifurcation was made. I feel that, as we have been saying, lots of things have improved. It is not that scheduled castes and scheduled tribes have remained where they were at the in 1947 or subsequent years. They have progressed, but much needs to be done. Similarly, there has been also demands from all over country for incorporation of certain sections of people into the tribes. In Assam, there is a issue of 6 ethnic groups who are demanding that they should be also included in the list of scheduled tribes. So the commission is to look into these demands also, and I think it is not a paper tiger. It has performed its duties, but obviously, as they are students, if they secure 80%, their parents will always want them to get 90%. If they get 90%, parents will say, why 90%? You should be getting more.
Yeah.
So similarly, our expectations, citizens' expectations are always going high and high.
Yeah.
And I will not say it's a paper tiger. It has performed its duties that has been assigned to it, but obviously it can be always better.
Mr. Sherman Ali, the scheduled tribes, I mean the provisions that have been provided for, a lot needed to be done, a lot has been done, But have we got there? Has the provision achieved its target?
No, it has not definitely achieved the target because of many things. Number one, we are talking about National Commission for Scheduled Tribes. Yes, you have rightly said it has not performed its duty, its functions. It has merely remained a recommending authority type of thing. It has not done its other duties like investigation, monitoring, or addressing the complaints. It has not done. And secondly, the implementing agencies, they have not also done the implementation properly. There are a lot of all these funds meant for the scheduled tribes, scheduled castes. It has become a goldmine type of things for few contractors, few politicians, few people in the power. So that has to be looked into, that has to be improved. Proper monitoring and implementation need to be done. And for that, I think National Commission for Scheduled Tribes has to be more active, perform its duty fully.
More empowered, you mean?
Yeah.
Has to be given more powers?
Just to add to that.
Please add.
You have said that whether it's a paper tiger. I won't say that it's a paper tiger, but much is desired because National Commission for Scheduled Tribe has been established. It has got no own agency. It's a recommending body. They will say that this is required to be done. Unless it is implemented by the implementing agency, it got reduced to a paper tiger. I am giving the example of, say, Assam Human Rights Commission for appraisal of Mr. Bhattacharya and Mr. Ahmed. Assam Human Rights Commission is a recommending body. It recommends. The file goes to the Secretariat and it is kept in the desk. Likewise, Upar Lokayukta in Assam. It's only a recommending body. It has got no own agency unless and until own agency is provided for implementation, etc. The desired result is not achieved.
So what you are suggesting is that these bodies be given more teeth,
more power, yes,
and more,
yes,
and their autonomous implementing agency,
yes,
to implement what they feel, and not depend on the government for.
Yes.
So that means a lot of portfolios you want to take away from the government and give to the commission.
Yes, for proper implementation.
And by the way, sir, these commissions are all headed by retired judges. That's another.
That is why the criticism is that to establish the retired judges, these commissions have been established.
Okay, we'll take the questions now. Yeah.
Good morning, sir. Sir, my question is from executive. Sir, how far it is justified that the land of tribal belt are being taken for industrialization?
I mean, taking land away from tribals
for industrialization.
For industrialization, I don't feel it is allowed, if I am not wrong. But as far as your question is concerned, whether it is justified, now for economic development, a few moments earlier, one question had been asked whether there should be environmental concerns. There should be also concerns when we take up an economic activity, when we go for, say, establishing an industry in a tribal area. We have to take these things also into consideration. Now, your question might have arisen from, like examples in Chhattisgarh or Jharkhand or in such areas where the allegations of tribals being thrown away for establishment of industries have come up. I think it's a very valid question, and we all have to take the welfare of the people for whom that land belongs for like generations altogether. Their welfare, their development have also been taken into consideration while establishing industries there. But legally speaking, I think, if I am not wrong, I am not very sure about the legal aspect, but I think it is not allowed, particularly transfer of land, tribal land for industrialization, unless there is a notification or denotified notification of that particular area.
So before I come to you, I'll get in Mr. Sharman Ali. Sir, the point that was made here is tribal land being grabbed for industrialization. What has your experience been? Have you actually come across any such issues?
Yeah, around 4,000 bighas of land in Retd area, that is within tribal belt, have been given to Ramdev. So
Okay.
I think, I don't know. And there has been no conditions have been made that such percentage of the employment generated will be given to tribals or
So
to
who
the
has
citizens.
the government allocated, or is it the tribe that has?
The government in collision with the BTHC Council, BTAD authority have given around 4,000 acres of land to from there.
So now this is what the tribal land ownership.
This is basically a political stand.
I understand,
You see,
but I would like to get to, sir, and get to the larger point. Land ownership in tribes is a very complex activity.
True.
Now, for the state to acquire that land,
Exactly,
it has to follow a certain guideline. It has been prescribed, which makes land acquiring virtually impossible from the tribal areas, right? But the point that was made here is, how do you balance development, growth, and also allow the tribes to retain their originality and land ownership?
Yes, the protections are there. The land belonging to the tribals are non-transferable. But if you go to the provisions of the Land Acquisition Act, then we will find that for the interest of the state, for the development of the state, that can be dispensed with. Although you have rightly said that very difficult to be dispensed with. But for the requirement of the state, for the developmental activities of the state, one cannot say that I am immune. Absolute immunity is not there. That this is my tribal land, absolute immunity one cannot claim. If it is required, say for defense purpose the land is required. It's a tribal land, but for defense purpose the land is required. For the security of the state is required. For industrialization of the state is required. Then yes, very well. The provisions, applying the provisions, the land can be acquired for the development of the state, for the security of the state. So it cannot be said that it is absolute, that the land belonging to the scheduled tribe or scheduled caste cannot be acquired. The provisions are there.
Okay. It's time for us to head into a break. When we return, we'll continue the discussion on the tribal land. Welcome back. Continuing with the discussion on the 6th schedule, the National Tribal Commission. Yes, your question, please.
The Forest Conservation Act 1980 has snatched away the traditional right of the scheduled tribe. So they are affecting over their forest livelihood. But my question is that isn't that the violation of fundamental right under Article 19(1) E and G?
No, because in Constitution there are provisions where a special consideration can be given to individuals or groups who needs that protection. So I don't feel it's a violation.
So, the question was that the right of the tribe over the forest, with the Environmental Protection Act coming in, are the tribes being deprived of their own way of living and the dependence on forest? And to give you another information, sir, there is already a Forest Rights Act of the central government in place, giving certain powers to these tribes. In view of this, do you think the tribes need to be further empowered to get a right on the forest, which is where the environment that they live in?
No, a balance has already been made between the rights of the tribals and for the existence of the forest. I don't think that more power or more rights should be given to the tribals. Already the Forest Rights Act have come into being, and this has given right to the tribals to give allotment of the land to live in the forest where they are living for many years. So I don't think any more right should be given.
Sir, you would like to...
While protecting the forestry, in fact, as you have rightly said, provisions have been made to protect the interest of the tribal population or the indigenous population who are residing within the forest. That provision is also there. Many a time when the eviction notices are served that you are occupying forest land, so this eviction notice is given to you, you will have to be evicted. Then he or she takes the plea that I am an indigenous man and I am a scheduled tribe or scheduled caste living in the forestry for years together. So the provisions of the protection should be applied to me. In fact, there is provisions protecting the interest of the indigenous people or the scheduled tribe residing inside the forestry, irrespective of the fact that there cannot be inhabitation within the forestry, but that protection is given.
Next question.
How the National Commission for Scheduled Tribes deals with the cases of atrocities against the scheduled tribe communities of Assam?
As I have said, that if any complaint is received, say for example in a particular area the claim is that some atrocities are going on, then a complaint is lodged. The National Commission for Scheduled Tribe will look into the complaint, they will make an inquiry, and if it is found that yes, some atrocities have taken place, then as required under that provision, they will submit a report. If it is relating to the state, to the governor, if it relates to the center, to the president, and also it will be placed before the parliament. That is why I say that National Commission itself does not have the implementation power. Suppose they find that yes, atrocities have been committed, they themselves cannot take any action. For action, they will have to depend on the government. If the government takes the action, yes. If it does not take, then that is why I say.
So what you're saying is that eventually for implementation and for all such recommendation, and a reason is made available to the state or the executive to either choose to act or not choose to act. So that right is vested with the state.
As in the case of Human Rights Commission, human right violation, allegations are made, my right has been violated. Human Rights Commission makes the recommendation. Even there are cases when Human Rights Commission itself filed a writ petition for implementation of their recommendation.
So
that's the position.
So is it proper to seek to take away from the executive the decision not to act? It could be due to political, economical, various other reasons that the judiciary or the quasi-judicial body may not be able to fathom. So in a situation like this, if the implementing system is put into such institutions,
that will lead to the achievement of the desired goal. Otherwise, if you are dependent, an agency is dependent on other, then unless and until that other agency implement your recommendation, they are helpless.
So you would like to add to this?
Basically, when the Indian Constitution was framed, in the constitutional debates we find that each and every section or article was debated and discussed, and there were elaborate discussions on all these issues. And the fathers of Indian Constitution in their wisdom have allocated powers to executive, to legislature, to judiciary. And this is always reviewed. Suppose one particular goal or one particular power that has been given to one section has not have had that desired effect. Obviously, over years, why do you have so much of amendments to the Constitution? Constitution is sacrosanct, but it is not that we don't make amendments to that. It is always open to review, and reviews has been done, amendments has been brought in. So, if, as has been propagated by Justice Sharma, if these agencies have not been able to perform their duties, well, they are open to review, and the legislature in its wisdom should act on it. There is no bar on that.
But how do you stand on providing it with a certain level of autonomy for achievement of goal and for better implementation?
If you ask me personally, I think there should be a balance. We cannot give unfettered authority to agency also. So there should be a balance, and that balance is very, I should say, delicate.
And is there at the present time in the National Commission for Tribes? Do you feel that balance being there?
Well, they are doing their work, and only time will reply to that.
I'll ask you a more interesting question. You have been, over the course of the discussion, been trying to bring out a point that the reservation system as it exists needs to be broad-based. The tribal commissions, or if there could be better commissions for the purpose of meeting the requirements that you think or your political entity requires it to be, should be put in place, and especially consider the backwardness, the economic backwardness of a specific entity should also be brought on board. What exactly are you trying to put across?
Actually, you see, over the years after independence, whatever we have seen is that there has been numerous communities or areas where the people are lagging much behind even than the scheduled tribes or scheduled castes. Yes.
What, which area would you say?
You see, this one example I have already cited is that Sasar committee recommendation. If you go through the Sasar committee recommendations, Sasar committee recommendations had illustrated that Muslims in India are much backward than even the scheduled castes and scheduled tribes in many areas. And even in the scheduled castes, among the scheduled castes or scheduled tribes, on the creamy layer has got all the eases provided by our constitution. So what is the need of the hour? Forget about the communities, forget about the caste and tribes. If a change is made in our constitution to revisit the inequalities now existing in our country and to address those inequalities based on socio-economic backwardness, something new, some new entities should be brought in so that the real goal of the constitution enshrined in our preamble or in the article from 14 to 18, that is equal treatment before law, by giving unequal, by treating the unequals differently, could be achieved.
So the point being made is that a section feels, could be right, could be wrong, I'm not taking any sides. There is a section in this country that feels that the purpose of the constitution will only be met if that section is taken to a certain level of socio-economic growth. My question is, what about the larger section?
No, I did not mean that. I did not mean that.
No. My question is clear to him. I asked you a question,
I
you
did
gave
not
me
mean
answer.
that.
I know, but I'm asking him.
I was talking about equality.
I get it. Yes, sir.
Of all
My
sections
reply
of
will
people.
be that the beauty of Indian constitution, the beauty of Indian democracy, people who have failed in fulfilling their promises, Sachar Commission since independence, political entities who have been in power, they have failed, and that's exactly people in their wisdom have thrown them away, brought in a new regime. Let's wait for this new regime to work. Let's give an opportunity to the new regime to work.
Right.
If it doesn't perform, people have the right, people have the power to make a change as it has done in on other occasions.
Can you trust and can you for once allow him the chance to prove what he is being propagating?
I did not mean that. Whatever I wanted to say is that the provisions in the constitution giving treatment caste-based or tribe-based have not served the purpose over the years. The main purpose of the constitution giving some special treatment to the scheduled tribe, scheduled caste was to bring to make
parity, yes.
To make parity
and
among
development.
But over the years, over the 70 years, what we have seen that some sections of the people have become more backward, or amongst the scheduled castes or scheduled tribes or the targeted groups, even the backward groups of the people within the caste or tribe are becoming more backward. So the provisions in the constitution has not served the purpose.
Okay.
So a new provision should be made, giving emphasis on socio-economic backwardness, educational backwardness.
And that's why the present government's motto is "Sabka Saath, Sabka Vikas."
Right, sir. Last word from you, sir.
Let us not be political whether his government will do or
provision
the
will
earlier
not
government had done or not. The question is, when the constitution was framed, when the constitution was promulgated, this reservation policy was only for 10 years.
True.
But no government has dared to remove that reservation policy. It has been continued for years together, and now we are on 70th of year. in the Indian independence, and still this reservation policy is going on. And Mr. Ahmed had some point, yes, whether reservation should be on the economic backwardness or on caste basis. But the question is, how long this will continue? And even now, new demands have come that we should be included as scheduled caste, we should be included as scheduled tribe, and in the process, whether the real taste of democracy has lost or not. That is to be answered.
On that note, that's a beautiful note to end the program on. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.